Hi, I'm California Trust Litigation Attorney Scott Grossman. It is pretty common for me to get a call from somebody who wants to hire our firm because they're concerned there's either somebody who's going to serve alone as trustee, or they're going to inherit from the estate, and it just seems wrong that this person is able to do that. Well, in this video, I'm going to discuss disqualified persons so you understand that there are categories of people who are not permitted to serve as trustee and are not permitted to inherit from the estate. California law creates a presumption of fraud or undue influence where a person is a disqualified person. So the first thing I'm going to do is I'm going to discuss the categories of people who are considered to be disqualified persons. In the next section, I'm going to discuss the exceptions to the law, and you need to know right now those exceptions are very important because they are broader than most people realize. Third and last, I'm going to discuss what happens if the law does in fact apply to your situation. California's law on disqualified persons is a complex technical law. I am not going to go into every nuance of the law because if I did, this video would simply never end. I want you to understand in broad strokes how the law operates, and if you think it may apply to your situation, then do discuss this with a probate litigation attorney to see if in fact it fits your particular circumstances. Now with that, let's get into the categories of people who are disqualified persons under California law. There are 6 categories of people who are considered to be disqualified persons. The first, and I'm quoting the law, is the drafter of the instrument. So that's a little bit of legalese. What that means is the person who actually wrote the trust itself. Now that can be an attorney, but it can also be a non-attorney. We live in a world where people have access to software and online programs that allow them to draft trusts. So whoever it is that literally drafted the trust is considered a disqualified person. The second category of disqualified person is the trust drafter's spouse or domestic partner, relatives, and employees. So clearly the intent here is if somebody is drafted and they're not leaving it to themselves, but somebody close to them, we're going to make sure those people are disqualified as well. The third category of disqualified person is a fiduciary who transcribes or causes to be transcribed the instrument. And that's some dense legal language. What that really means is if you've got somebody in a fiduciary position, and typically that's going to mean that either there's a conservatorship in place, so we're talking about the conservator, or there's a durable power of attorney, so we have the attorney in fact under that durable power of attorney, either actually writing the trust themselves or having somebody else write it. In those circumstances, that fiduciary is going to be a disqualified person. The fourth category of disqualified person is the fiduciary's spouse or domestic partner, relatives, and employees. Just like we discussed before, we want to make sure the person who has done the wrong thing doesn't benefit by leaving trust property to somebody who's close to them, but not themselves. The fifth category of disqualified person is the care custodian of a dependent adult. A dependent adult is somebody who is 65 years old or older and either of the following 2 things: unable to provide for their physical health, food, clothing, or shelter, and had trouble managing their financial resources or resisting fraud or undue influence due to a cognitive impairment. The sixth and final category of disqualified person is the spouse or domestic partner, relative, or employee of the care custodian. Just as we've discussed before, we don't want the care custodian to benefit simply because they've had the trust gift property to somebody who's close to them. There are 6 exceptions to the law on disqualified persons. The first of those is if the prohibited transferee, that means the person who's actually receiving the property, is within 4 degrees of relationship to the trust settler. And the way you figure out 4 degrees of relationship is simply drawing out the family tree and see if within 4 hops, skips, or jumps, you've got a relationship to the person who created the trust. The second exception is for a cohabitant of the settlor. Cohabiting is just what it sounds like, somebody who is living on a full-time basis with the person who created the trust. The third exception is where an independent attorney has signed a certificate of independent review. Now, California law sets out what has to be in the certificate of independent review, but what this really means in practice is this. You have an attorney who did not play a role in drafting the trust. That's what makes them independent. They on their own have to evaluate the situation and make sure that all the criteria for independent review are met. If they are, then they have to draft the certificate of independent review stating under penalty of perjury that they've done the required examination and they are satisfied that in fact the trust reflects the wishes of the settlor. The fourth category is where the trust was approved by the probate court in a substituted judgment proceeding where all of the relationships have been reported to the court. Now, what that really means is if there was a conservatorship proceeding in which a petition was filed, notice was given to everybody who is supposed to get notice of that particular proceeding, and in it, there was a request for the court to approve the creation of a trust that has these otherwise prohibited terms. And with everybody who's entitled to get notice actually receiving that notice, that petition is still approved, then the trust that's been created will be valid. The fifth exception is where the gift to the disqualified person is $5,000 or less. Now, to some people that seems unfair because why should a disqualified person get anything? Fair or unfair, that's the threshold that's set by the law. The sixth exception to a disqualified person is where the otherwise disqualified person proves by clear and convincing evidence that there was no fraud or undue influence. Understand, clear and convincing evidence is the highest standard of proof in any kind of civil proceeding. Now, that means that the person who otherwise would either be disinherited or subject to removal as trustee has been able to marshal a considerable amount of evidence in order to show that these terms reflect the true intentions of the trust settlor. If the law on disqualified persons does apply in your case, then that means the disqualified person is treating as having predeceased the settlor, and when they died, they are treated as if they died without having any spouse, any children, grandchildren, or other issue. The effect of this is to say that this person doesn't inherit and neither does anybody else who's related to them. If you're able to prove that a person is a disqualified person, they can also be held liable for reasonable attorney's fees and costs in the litigation to determine that they are in fact a disqualified person. Now you should have a pretty good idea of where the disqualified person law may apply and what the exceptions to the law are. It is certainly a unique type of trust litigation. It's not going to apply to all cases, but our next video on objecting to the trustee account is something that applies in every trust case. If you found this video helpful, then please hit the subscribe bell, leave us a comment. We'll be glad to respond if you do, and give us a thumbs up.